is, if they're unenforceable, what does the court do, with that, with regard to TCJ's membership? As you see here, you've got 3 members, TCJ Ventures, Chicane, and Code Zero, who are the existing members now. So the first question is very easily solved. Mr. Real and TCJ made judicial admissions that the ECI operating agreements, the 2 agreements, are unenforceable. He said that he didn't consent to them, that there was no authority for them, that the TCJ agreement barred what he did. Those are judicial admissions that invalidate those agreements, period, stop. All of the defensive arguments, all 81 pages of them in the reply, are all barred by this, by black letter law on this topic. And, we all knew that Mr. Ryle and TCJ would file an amendment. My biggest concern was that they would file and get rid of these judicial amendments, which would make it much harder. But they didn't. And the Amaro case, which is tab A in the courtesy binder that we provided, is just 100% spot on. And it also answers this question that's raised by Ryle and TCJ about standing. We don't have a standing issue. We're not trying to enforce any provision of the TCJ agreement. We're not trying to sue TCJ based on any provision of their agreement. They have judicially admitted that they do not have, that when Mr. Montgomery executed the 2 operating agreements, he didn't have authority. And this is almost 100% the same argument that was made in the Amaro case, where the LLC said our president didn't have authority to sign these documents, and then they turned around and they tried to sue to enforce the agreements, and the Court of Appeals pretty easily dismissed it. And they said, you can't have it both ways. You can't argue it's valid and then judicially admit that your president was not acting with authority. And that's not a standing issue. That is a judicial admissions issue. And once you have a judicial admission, it binds them for the rest of the case, or as long as the judicial admission is live. And for here, for purposes of this trial, it's live. They haven't withdrawn it. Even their own evidence or their own case law, in their response, confirms that if you violate a bylaw, it's voidable. And they make this interesting argument, which is not supported by any case law, that says, oh, well, the TCJ agreements, they don't use the word voidable. Well, that's not a requirement. And there's no case law that says it's a requirement. If you violate the bylaw and you sign something without authority, it's voidable. And so what typically happens is parties can waive it to make an agreement enforceable. But the people who can't waive it are Mr. Montgomery and any of the counter defendants. And there was the response raises this argument because in the 3rd MSJ, we said that they triggered voidability by taking steps in this litigation to disaffirm enforcement. We cited the Nice case, which cites the Cole case. And Ryle TCJ's argument becomes, oh, well, what does disaffirm mean? Well, I think disaffirm pretty obviously means exactly that. You take some steps, say that contract's not enforceable, which they 100% did. But more importantly, the Cole case, which when you read it, it goes all the way back to 1888. And in 1888, the Supreme Court said that you can have a voidable contract when somebody who's basically got the authority takes some manner to repudiate or annul it, which is 100% what Ryle and TCJ have done. They have repudiated the ECI operating agreements, and they have said, we don't want those agreements to be enforceable, even though we still want to be in the, within ECI, which is the crux of the problem. You don't get to have your contract and defeat it too, which is exactly what they're doing. And then in the reply, we noted that the distinction between void and voidable really only comes down to kind of ratification issues. If you have a voidable contract and it's determined that it was voidable, then it's as if it was never formed. It goes away. There is no ECI operating agreements, period, stop, based on the judicial admissions. And as we pointed out in the reply, in 81 pages of response, 182 footnotes. The word judicial admission does not appear. That has been the centerpiece of our argument from the beginning. There's also a judicial estoppel argument based on the positions they've taken in the arbitration. We don't mention it in the reply because it wasn't addressed in the response, but it has the exact same effect in this case. But there's really no reason to dig into that because Mr. Ryle and TCJ, even in their summary judgment evidence, continue to disaffirm the ECI operating agreements. So contracts are torn up. So what happens? Well, the easiest thing that happens is that the breach of contract claims go away, and any breach of fiduciary duty claims based on those contracts would go away, and any rights to books and records based on the contracts go away. But obviously that doesn't get us out of the case, and we'll get to that in a minute. But more importantly, all those arguments they make, ratification, waiver, Texas Business Organization Code, they are not in any way a silver bullet to this summary judgment motion, because Texas Supreme Court case law, and it's all over the place, the judicial admission, not only do I, as the movement, not have to make proof of the fact, Ryle TCJ cannot make an argument legally that says that they provided consent to sign those operating agreements. And and I always thought that was going to be a problem for them, which is why I thought they would back off of the unenforceability of the operating agreements and just say, yeah, they're enforceable and let's proceed. Now, obviously that would hurt them in their arbitration, but that's neither here nor there. The other problem they have is these affirmative defenses are unpled. They're not pleading, nor would it make any sense for them to plead that Ryle TCJ have ratified or waived the lack of enforceability of the operating agreements. They don't even get to make the argument out the gate. But more importantly, the Bob Montgomery Chevrolet case, ratification occurs by the person with knowledge who has the right to then bind the company. And here's the problem with that. The only person that can do that is Mr. Ryle. He is the only human that can
Mr.
submit
Lemoyne,
evidence.
you have,
Mr. Montgomery has already...
Mr. Lemoyne, you have 5 minutes left, just FYI.
Okay, thank you, Judge. Judge, did we not have an hour for this hearing?
It's on the docket for 30 minutes.
I was told we had an hour.
Well, let me.
Okay, so he can't.
Rhonda, can you check that? I have my next hearing in 15 minutes. So.
Yeah, Judge, I didn't realize that.
On this particular docket, it was originally set for an hour, but we only had about 30 minutes to squeeze it on this one.
Mr. Lemoyne, do you want to move this, or do you want to keep going forward? We just don't have. We're so slammed right now that I don't know that I can give you an hour. I'll give you as much time as I can, but I want you to have enough time. I know this is an important motion.
Well, I mean, I think I can probably get through the next couple of slides fairly quickly. The other problem they had is even if they could ratify, and even if they had pled it, and even if they could get around a judicial admission, their best evidence is based on hearsay testimony, where they're trying to use a conversation between Mr. Montgomery and Mr. Ryle, and then they use Mr. Montgomery to be the shepherd of that evidence. Well, that's quintessential double hearsay. You can't say, I had a conversation with Mr. Ryle in Starbucks, and this is what I conclude. And that goes to the evidentiary objections. And the way we try to do evidentiary objections is that the court can review in full exactly what we're arguing without having to have us do a bunch of arguments. But obviously, we could do those at a later date. So what happens, it's based on the case law, and Mr. Ryle and TCJ have no answer to the argument to the judicial admission argument. They just don't have one to go to the Court of Appeals on. So the operating agreement's unenforceable. So that doesn't completely solve the problem, because Mr. Ryle's argument is, well, TCJ, get to be a member of ECI when the agreements go away. Well, I would ask him which case says that, because there isn't any. And the predicate part of the statute for how a party becomes a member is they have to have capacity, which is 101.102A, which, once again, it's in the third MSJ, but Mr. Ryle doesn't answer the question, doesn't say anything about this particular provision. He talks about B, about how you can become the things that you don't have to do to become a member. But the evidence is that there was no other mechanism for TCJ to become a member. And remember, the case law says if it is voidable and determined void, it's a nullity. And so they don't have an operating agreement to get to. And again, they just straight up say, I mean, they basically plead the capacity defense for us in their factual allegations. There's also a couple of cases that speak to this, both Amaro and HTO. They're not 101, 102 cases. There are no cases. That's why it's a novel issue. No one has ever done this where they've tried to say the operating agreements are invalid, but I still want to be in the membership. I've looked nationwide and cannot find that argument, which is why we're asking the court both to grant the summary judgment, but to certify the question to the Dallas Court of Appeals so they can weigh in on this novel issue of law. The obviously lack of membership status, if they're not a member and they don't have a contractual right, all of the fiduciary duty claims collapse, all of the breach of contract claims collapse, all of the statutory claims that they can bring collapse. And there's some kind of other issues where Mr. Rowell's trying to say, well, I consented to be a member. Well, one, it's totally irrelevant. And two, the question on the table and the judicial admission that binds him prevents him from saying that he consented to be to the operating agreements. And the operating agreements are the gateway into the case. Also, there's no evidence that anyone else, any of the other members of ECI, agreed to be members without valid operating agreements. In fact, the evidence is to the contrary of that. And of course, Mr. Rowell can say whatever he wants. I'd like to consent to be Travis Kelce. I don't get to be Travis Kelce unless he lets me do that. And he wasn't even involved in the discussion. So his testimony about what he thinks, what he wanted to do, his wish list is completely irrelevant. So I think this is important just from an equity standpoint, Your Honor. There's option one for the court. The agreements are enforceable. Mr. Ryle and TCJ are mad because they're in an agreement in a relationship with an LLC they didn't agree to. Option two, the court says they're not enforceable, what Mr. Ryle asked the court to do, but then you force the other members to stay in the LLC, which is the exact flip other side of the coin of what Mr. Ryle and TCJ say you shouldn't do. Judge, you shouldn't make us be in a relationship or honor these contracts because we didn't agree to them. Well, what's good for the goose is good for the gander. So option three, and that's the option we propose to the court. You tear up the contracts, they become a nullity, and we separate the parties. And the important part of that is this summary judgment doesn't end the case. It just simplifies it a lot. And what it does is it really reduces the case down to an equity case. Mr. Ryle and TCJ made an adult decision to attack those operating agreements. I've never quite seen anything like it before. But when they did it, they picked their type of remedy, which is it's basically an unwinding, whether you think it's rescission or restoration, or money hadn't received. That's not for today. We're only here about why their claims are invalid, not what the counter defendants' claims would look like. And then the last thing, well, your Honor has it, what the MSJ would look like. And I will conclude, on this. This is a rare occurrence. I've only been in 24 years, or 23, I've only been in about 4 cases where I thought there was a novel issue of law. When I tell you there is no case where this has ever occurred, it is right 100% down the middle of the fairway of what these types of interlocutory appeals should be for, because this case is going to take a while. And when I say show me the cases, Mr. Ryle and TCJ have no case. I mean, no case that says they can do what they want, which is to invalidate the operating agreements and remain a member. And so I will, given the amount of time, that's it for me, Your Honor.
Okay.
Absent any questions from the court office.
Response.
Mr. Anwar, can you please share screen? And you can go ahead and jump to slide 3 in the interest of time. Your Honor, before we dig into specific questions, which we'd like to turn to immediately given the time, we want to reframe today's discussion around the question posed by the movements. Specifically, is TCJ a valid member of ECI? And it requires us to look, Your Honor, first at what each party has alleged. Mr. Ryle has alleged that he consented to the transaction. He did not consent to the specific terms in the agreement, but that TCJ is a valid member of ECI. Mr. Montgomery also alleges that
Is this contrary to what the position you took in arbitration, though?
No, it is not, Your Honor.
Okay.
Mr. Ryle specifically stated that he did not consent to the specific terms in the ECI agreement and does still contest whether or not there are breaches of the TCJ agreement as a result. He does not dispute whether TCJ is a valid member of ECI. And so if we go to the next slide, Mr. Anwar, this sets up movement's flawed basis for relief. Mr. Ryle alleges that no consent occurred, but he doesn't allege that there is an invalid ECI agreement. That is what movement's basis for relief is. And so the two fatal flaws, Your Honor, are first, movements conclude that the ECI agreements are invalid as a matter of law based only on that alleged lack of consent to the specific term.
So
they're leaping.
What I'm trying to figure out, and maybe I'm just missing the distinction. So if he didn't consent to the specific ECI agreement terms, how was there a contract?
Let's jump to slide number, I believe it is 24. And that is our third responsive argument, Your Honor, which is that if the ECI operating agreement ceased to exist, movement.
Oh, sorry, Mackenzie, can I interrupt you?
Yeah,
sorry
absolutely.
for a minute. Okay. I think he's actually going to something I was going to discuss, which is slide 14, Kamran. Your Honor, I think you're asking if there was no consent by Mr. Ryle, could this agreement still be valid and not void?
I'm just using basic contract principles, which is if you don't consent to entering into an agreement, then there's not an agreement. And if you don't consent to certain terms within the agreement, there's not an agreement, right? You have to have a meeting of the minds.
I understand what you're saying, Your Honor. And a distinction that we need to draw that's very important is we're here representing Mr. Ryle. We do not represent TCJ directly. We only represent them derivatively. TCJ has another 50% member and manager, Mr. Montgomery. And as you know, the disputes between Mr. Ryle and Montgomery are in dispute in the arbitration, not in this case. So there's two really important things there. The first is that distinguishes all the cases Mr. Lemoyne's been talking about today, including Amaro, where the LLC itself appeared in a proceeding and said this contract isn't valid and then tried to sue a breach contract claim. What we actually have here is a dispute between Mr. Ryle and Mr. Montgomery about whether or not Mr. Montgomery, acting as manager for TCJ, got all the consents he was supposed to. There's no dispute that Mr. Montgomery signed the amended ECI operating agreements. There's no dispute that he signed them in his capacity as a manager of TCJ. And everyone in this case on the ECI side has testified they thought.
How do you distinguish the Amaro case? Is that what it was called, Amaro?
Yes. So in the Amaro case, the LLC itself was the party to the lawsuit, and the LLC itself said this contract isn't valid. Here, we have one of the two members of TCJ saying, I didn't consent. We have the other one saying, no, yes, you did consent. And so we have a fact issue there that's going to be resolved in the arbitration. But more importantly, from our perspective, apart from that fact issue, is that even if Mr. Montgomery didn't get Mr. Ryle's consent, the contract, the ECI operating agreement isn't void. It's only voidable. And it's voidable at the decision of the person who was wrong.
That was a question I have about that distinction, and I may want to hear from Mr. Lemoyne on this. If the contract is voidable, kind of what does that mean in this context?
Absolutely, Your Honor. If you could go to slide, sorry, we're jumping around, slide 23, comma. So essentially, if you want to get in the weeds, I know we don't have a lot of time. Originally, ECI was focused on this section 9.01 of the TCJ agreement. No one on the TCJ side thinks 901 has been breached, and that's not alleged in the arbitration. We only allege violations of Article 7 in the arbitration. That's important because there's nothing in Article 7 that says the result of Article 7 being violated, which is where it requires certain consents for managers to take action. Nothing in there says it's void if you don't follow that. So that means it's voidable. To be voidable, and in fact, they cite this in their own case. They cite Love Terminal Partners in their reply. Love Terminal Partners clearly states if a contract
you're showing me different cases. I think maybe are we on the right slide?
We're on the right side, Your Honor. I'm sorry. They cited a case in their reply that I don't have in my PowerPoint, but it's actually even clearer than both of these. So in Love Terminal Partners, they say if it's merely voidable, an act is valid until adjudicated and declared void. And that's the same thing these cases say here. A voidable instrument has legal effect until judicially set aside. And so what they're trying to argue in this case is essentially that because we're having this dispute with Mr. Montgomery about authority, and because we say that in our suit, that you should somehow take the leap to say we have now asked that this voidable instrument be void. But nothing in our pleadings in the arbitration or here say that these agreements are void. They don't say we're not asking for rescission. There may be a time where we decide to elect some type of remedy that we haven't yet, but essentially ECI is trying to force our statement about lack of authority in our underlying dispute with Montgomery into getting themselves out of this contract. And that's not how voidable contracts work. We, as the person who would have been wronged by the voidable contract, get to make that decision. And we have not made the decision to do that, which goes also to our initial standing argument, which we think is important here, because what ECI is trying to do is say, Your Honor, we've looked at...
Just a second. So, Mr. Lemoyne, there's this quote here that I think is fairly compelling on their side. Since a voidable instrument has legal effect until judicially set aside, and then it goes on to say you cannot gain restitution, but must sue for revision of the release. Are we maybe jumping the gun again until there's a determination of whether or not the underlying documents are void as opposed to voidable?
No, Your Honor, because first of all, so there's two reasons. Number one, that's kind of the same argument that was made in the Amaro case, where the plaintiff said, well, we're still trying to sue on the breach of contract. And the court said, no, you said you didn't have authority, therefore there is no valid contract.
But in that case,
why is there no valid contract?
But Mr. Lemoyne, in that case, wasn't it the actual LLC suing as opposed to one of the individual members?
Which is also what's happening in this case, Your Honor. I mean, I don't want to take over Ms. Williams' screen, but I'm reading from the third counterclaim, paragraph 194. Ryle and TCJ assert this claim for wrongful denial of access to books and records of ECI. Every one of their claims starts out with, Ryle and TCJ. So they are bringing the claim on behalf of TCJ.
Okay.
And the reason why TCJ can't...
Whoa. Ms. Williams, you does seem like you brought the claim on behalf of Ryle and TCJ.
We've brought it derivatively on behalf of TCJ, Your Honor, which is an important distinction because in Amaro and the other cases he cited, H2O Solutions, the LLC itself had an attorney, made an appearance in the case as the LLC's attorney and made statements on behalf of the LLC. We have brought statements by Mr. Ryle individually, derivatively on behalf of TCJ. TCJ is actually in this suit without counsel because Mr. Montgomery and Mr. Ryle can't agree on how that would work. So essentially TCJ is represented partially by Mr. Ryle and partially by Mr. Montgomery, but we do not speak for TCJ LLC as an entity. We speak for Mr. Ryle derivatively on their behalf. Now for shorthand in the complaint, we have, instead of saying Ryle derivatively every time, we shorthand defined it that way.
Okay. Just I'm trying to think my way through this. So
Yep.
To get the distinction here. So TCJ, if TCJ was making this argument that the contract was void, then Amaro would apply. But because it's derivative and no determination, there's no determination between let's say that there's a finding by the arbitrator or whatever that this contract was void as opposed to voidable. Okay, so I'm sorry, I'm just kind of thinking through all this.
No, I understand, Your Honor. You're correct, but I also just want to point out, we as Ryle and derivatively on behalf of TCJ have never said this agreement is void. That is not in our pleadings. We don't seek relief to have it declared void. We don't seek relief to have it rescinded. They're taking the judicial admission Mr. Lemoyne keeps talking about is just our statement that Mr. Montgomery didn't have the internal consents and authority that we claim he needed to have.
What is the remedy if he didn't have consent? What is the remedy you're asking for? Aren't you trying to void the contract?
We're currently just asking for monetary damages, Your Honor. I do think there may be a point at which we could elect to try to do something else. We have not done that. We have not asked for rescission. We have not asked for anything to be declared void. And that is what is so odd about this motion to us. And I don't want to harp on standing, but I do think it's important. ECI has essentially come in and said, you pled no authority. We went and looked at your agreement. We think this should be void, and we're choosing for you that it's void and you should get out of ECI. And our position is that that's not something they get to choose to do. It's not something we have chosen to do. And so that is still very much an open issue in this case.
Your Honor, can I have a brief response?
Yeah, we're almost done. So go ahead. Let him have access. If you want to show me any slides, this is the time to do it. Mr. Lemoyne.
Yes, yeah, Judge. I'm trying to get to that. I'm trying to get to this.
And I will say that this distinction between void and voidable, I kind of felt like when you were arguing this that I kind of had that same question in my mind, and reading the briefing and everything, I think it kind of comes down to that.
So two answers. So three answers. Number one, there is no case that draws a distinction between somebody trying to bring a derivative claim on behalf of an LLC and it being brought directly. If the claim is invalid because the entity cannot bring it, then the individual can't bring it, which is exactly the proposition that Amaro stands for. Also, the Amaro case, in this last part where they say, you cannot assert the transaction was defective, Heron had no authority to act, and then argue that the other side is bound and breached, which is the exact argument that they're making. They are saying, on one hand, there was no authority to enter in this, and that's just 101 contract formation. They came to the court with a direct and a derivative claim and said there was no authority to execute these agreements. They don't then get to decide, but we don't want to take the benefit of voidable because that hurts us. Either it's enforceable and you can do it, you can sue on breach, or it's not, which is what Amaro says. It's what HTO says. And I think what Ms. Williams has pitched is another novel issue of law, because there's no case out there that says because Mr. Ryle decides to bring this derivatively, that he gets to escape the lack of authority for the contract to be executed. So, I mean, to me, that's straightforward. Either the entity at a derivative level has a right to bring the claim or they don't. And Mr. Ryle pled himself out of court. There's not a fact issue.
So let me ask this. So I'm looking at this, the quote here. This in the Amaro case, was Amaro an individual and Heron? I guess Heron was an individual. Was Amaro an individual, or was that the name of the LLC?
Amaro is the name of the LLC. Heron, I think, was the president or some kind of agent, and they said then the LLC itself said he didn't have authority. But then they tried to sue on a breach of contract, and the court said that's a unequivocal judicial admission. You don't get to contest it anymore. And even though you may plead other things, other facts, you are barred by that, which is why the case is 100% on point.
Okay.
And the effect of what happens when it's not authorized, well, it's just voidable, right? It becomes void because they have now judicially admitted that it's a voidable contract, which means it turns into a void contract when the court renders a decision that the contract's not enforceable because of lack of authority. And there's no requirement in any of the cases that says that, and I want to get to the, yeah. And so the Cole case from the Texas Supreme Court in 1888, I mean, usually when quick cases say, somebody has to get it declared void, they're talking about whether or not somebody has authority to make that argument, usually in the assignment context. Here, I don't have that problem. Mr. Ryle literally did it for me. He stepped up to the plate and he said, I'm one half of TCJ. You have to have 100% authority from both parties, and I did not consent, which makes it repudiated. And so it's just kind of black letter law that he is judicially barred from contesting that argument, which invalidates the contract.
But the contract has not been invalidated by any court or arbitrator, correct?
No, Judge, that's step one. Court determined that the contract is unenforceable based on lack of authority, which makes it voidable. Or I mean, it makes it void.
So,
right?
so
Void,
there's a fact issue about whether or not consent occurred, right? If there's a,
No, Your Honor.
is that something that's being?
Yes, there is, Your Honor.
So does that?
Judge,
Is that something that Judge Ginsburg in the arbitration is going to decide?
Yes, Your Honor.
Has he decided that?
but
If I may share screen, I think that the chart that we made will help to clarify this issue.
All right, go ahead and let her share
Number
screen.
Judge,
5,
I mean, I will, but I would say this. You cannot, the judicial admission binds them in this case. It does not matter that Judge Ginsburg might decide something differently. In this case, they are barred from contesting Mr. Ryle's consent. Just period, stop.
Your Honor, movements characterize this first red box as a judicial admission that conclusively establishes, quote, the invalid ECI agreements. However, that is factually incorrect, but also Ryle, as a 50% owner of TCJ, cannot judicially admit for TCJ the invalidity of the ECI agreement. It skips the orange middle boxes, which is that currently there is a fact issue, a dispute between Mr. Ryle and Mr. Montgomery regarding the consent issue. Furthermore, there are TCJ level agreement disputes that are distinct from the Amaro case. There was no dispute regarding the Amaro entity itself or among its members as to what it was asserting. And so herein, because Mr. Montgomery and Mr. Ryle, who own TCJ 50/50, are in dispute, we have to look not only at the fact issues inherent in that consent dispute, but we also have to look at the effect of the TCJ agreement on that consent issue. And so then we would reach the question, but they're really trying to jump the gun and immediately get to, which is the first fatal flaw, this question of the invalid ECI agreement. But even more, Your Honor, we've talked a lot about the voidability and voidness of the agreement, but they're making a second fatal leap, which is that even if movements are correct and the two bases for relief are the same, which they're not, then an invalid ECI agreement does not mean that TCJ has no membership. It doesn't make TCJ's membership invalid as a matter of law. It's not. And if we jump to 23, we can talk about that. But I don't want to jump to that, Your Honor, if that's not something of interest for you this afternoon.
Well, why is that? Void ECI operating agreement does not mean.
So when we
How else could they be? How else could they be a member then?
If we turn to the next slide, slide 26, and look to the Texas Business Organization Code 101.103, A person may be admitted as a member of a company through an operating agreement, but that's not the only way an entity or a person becomes a member of an entity. If the company's records do not state a date described by subdivision 2, the date the person's admission to the company is first reflected in the company's record controls that issue. And so necessarily, as a matter of law, we look next to other documents that would show whether or not TCJ was a member. And in fact, TCJ has been treated as a member of ECI since the beginning of December 2017. So if we turn to slide 28, Mr. Anwar, we can see that in the ECI tax returns, in ECI's communications with financial institutions, in ECI corporate documents, and in ECI contributory documents, that ECI itself has treated TCJ as a member for over 5 years. And now they seek to, on the basis of an incorrectly characterized, quote, judicial admission, undo the last 5 years. That is not a defensive MSJ. They are taking us out of the correct procedural posture, Your Honor, and moving this into an affirmative relief of rescission to remove TCJ from ECI. There is no dispute that TCJ is a valid member of ECI. Movements are instead seeking in this motion affirmative relief to rescind TCJ as a member, and that is not only substantively improper and incorrect, that is procedurally improper and incorrect.
Okay, so guys, that's it. That's it. So I will say, Mr. Lemoyne, this is a lot closer call than the other motions you brought. I kind of wish you brought this one first and not anyway, but that's, you know, water on the bridge at this point. I do think this is a tough issue. So I guess for me at this point, I do think there's a fact issue. I will say that if there's a final determination that this this contract is void, the underlying operating agreement, this contract is void, if that's something that's determined by, I guess that's something Judge Ginsburg is going to eventually decide. Is that right?
Well, the parties have not put the voidability or the void nature of the, as Ms. Williams stated, you know, we have not pled to void the agreement and the underlying arbitration.
So if at some point there's a determination made, and I want you to quote me, this will be kind of fun to watch, quote me in this if it happens, I'd like you to bring this motion back to me. If there's a judicial determination, a final judicial determination that this contract is void, or that they plead to have this contract declared void, then I want you, Mr. Lemoyne, to bring this motion back. But for now, the motion's denied. You guys have a great rest of your day. Got to get to the next hearing. Thank you, guys. And great, really good briefing and argument by both sides.
Thank you, Your Honor.
All right, I think we have another hearing. And get me an order on that, guys. All right, Alvin Jones versus Omar Lopez. Are both sides here for that?
Your Honor, this is the withdrawal hearing. I am present. I don't see counsel for the defendant present, but they don't have an interest in the hearing.
Judge, the defendant is on the phone with me. He was having some Zoom technical difficulties, so he wants to appear by phone.
The defendant or Alvin Jones?
Alvin Jones.
So what's your name?
Alvin Jones.
Alvin Jones, I'm sorry.
This happened last time. Mr. Tatum, what, sorry, I'm saying your name wrong. Is that right, Tatum?
Sorry. Tatum, yes, Your Honor.
Tatum or Tatum?
Tatum.
Tatum, sorry about that. Okay.
No.
So what has happened since the last time we talked?
So since the last time we talked, you know, you had indicated that Mr. Jones would be confronted with a choice between either executing a settlement agreement following the tender of policy limits, or we would be granted withdrawal. Mr. Jones has not executed that settlement agreement and has indicated that he does not intend to. So therefore, we are just back asking for permission to withdraw from the case.
Is that correct, Mr. Jones?
No, sir, incorrect. I provided 4 documents that I submitted to you for evidence, and also I submitted to KRW lawyers as well. They sent me a release to Attorney Ralphie Red Dog Jones. He sent it to me, where they received a check on September the 15th without my knowledge, and on December the 5th, Mr. Red Dog sent me a copy of it. So they've been having a check way before they submitted the so-called revised release settlement agreement, which I object.
Your Honor.
Yeah, let me pull up what we have. Let me see. He did send something in. I didn't get a chance to look at it. Let's see.
Your Honor, one of the documents is a STARS demand that I submitted to Kayla McCabe, the claim adjuster, back in October the 31st, 2022. However, on the document, I made an error. It was October the 31st, 2021. And also, I sent you a copy of, as I stated in the last Zoom meeting, that they offered me $22,483. You should see a letter that was sent by U.S. mail as a diversionary tactic for delay regarding that same amount. And then when I filed the case in the courts per se on January the 5th, 2023, and then in June, when I signed a contract with KRW, it was my understanding when I spoke with Mr. Tatum that they was going to possibly litigate if they didn't get the STARS demand. So in reference to the STARS demand, I submitted the same STARS demand to them back in October of 2022, where they didn't respond to the STARS demand.
So, Mr. Jones, wait, Mr. Jones. So, what you submitted to me, what you sent to me, is an unsigned release and settlement agreement, correct?
Yes, a copy of that.
You've never signed it, correct?
Correct. That's the one that Mr. Red Dog sent me. That was the first time I saw that one.
And you've decided not to sign that. Is that correct?
Yes, I'm not in agreement with that, Your Honor. I object to that.
Mr. Jones, I think you're making a horrible, horrible mistake, but I can't save people from themselves. You know, sometimes my court reporter criticizes me because she says I tried to do the right thing, and sometimes it comes back to bite me. And so I've done what I can. I think you're making a terrible mistake. Eventually, I think you're going to see why. I've explained this to you extensively about why you need to. But anyway, if there's anything else I can do, I've told you what I thought you should do. You're not going to do it. That's fine. I will go ahead and sign the order allowing you to withdraw. I think you're going to really regret this decision in the long run, but I've done what I can. So good luck, Mr. Jones. I'm going to allow him to withdraw.
Thank you, Your Honor. And may we be excused?
You may.
Thank you.
Okay. Do we have everybody here on the Young Republicans case?
Yes, Your Honor.
I believe so, Your Honor.
All right. Tony, are you ready?
Yes, Judge.
Let's go on the record on DC 23-18308, Texas Young Republican Federation versus Chad Cohen et al. Council, make your appearances.
Connor Ellington for defendant Chad Cohen.
Also, Tony McDonald for defendant Chad Cohen. Mr. Ellington's going to do the presentation on this, but I wanted to be available.
And then James Ringel and Jimmy Breimer for plaintiff, Texas Young Republican Federation.
Okay. Let's proceed.
All right. So this is going to be defendant Chad Cohen's motion to dismiss under the Texas Citizens Participation Act. So at the outset, we'd like to note for the court that there's his motion to dismiss in front of the court today. There is TYRF's response, and then defendant Cohen's reply brief. So at the outset, since the filing of the TCPA motion to dismiss, TYRF has filed a second amended petition with this court. They have changed, or they claim that when they originally sued in this lawsuit, they were a nonprofit corporation. They now claim that they were mistaken in suing as the nonprofit corporation, and they now are an unincorporated nonprofit association. So just at the outset, and we'll go more into this in TCPA.
Let me just ask this, because I haven't looked at the first amended petition. Is it first or second amended?
It is now second amended petition.
I don't think I've seen that one. Let me see. When was that filed? It's not on the system.
Your Honor, I believe I filed it simultaneously with the response.
Okay.
Yeah.
Let me share screen what I have. Okay. Oh, I just misread the bottom. It said first amendment petition. It is second amendment. Okay. All right. So what changes were made between the second amendment petition and the petition that was alleged that the motion dismissed was filed against?
So to begin, okay, so this is between the motion to dismiss was filed in relation to the original petition.
I apologize. I need to take a quick break.